Ladies and gentlemen of the press, people of freedom and lovers of freedom, today we have a brand new update for you. Today, the 17th day of the month of May 2026, we have something for you that will definitely keep your interest. Now, the appeal court has now officially released details of how the proceeding involving Nnamdi Kanu as the appellant court will go down inside the appeal court in Abuja. And in this video, we shall be telling you every single thing that you need to know. You will get to understand how Nnamdi Kanu's case may proceed, and you also get to see the chances that Mazi Nnamdi Kanu have regarding to his freedom. You will also get to understand whether he is in the best position to defend himself based on the structure and style of appeal court proceedings. Now, after you watch this video, definitely you will understand what could happen on the first day and what could happen on the final day and how the entire process may unfold. So I dey be you now. Let us begin this video with everything that has been released and every single thing we know so far and how the proceeding are expected to go down. Now, the first major thing expected in the appeal court is this. The court will sit with three judges. Unlike the Federal High Court where a single judge handles the proceedings, the appeal court panel will consist of three judges sitting together on the bench. And also, apart from the fact that there will be three judges, the court structure is expected to look compact and well organized. One section will be reserved for the judges, while the other section will be for the legal counsels and lawyers involved in the case. Now, we already know that the federal government's legal representation is expected to be led by Senior Advocate of Nigeria, Chief Adegboyega Owo-Molo. On the other side, Mazi Nnamdi Kanu will appear as the appellant in the matter. So this is how the structure is expected to look. Now, behind Nnamdi Kanu and his legal team will be other counsels assisting him. Likewise, behind Chief Awomolo San, there will also be additional lawyers assisting the federal government's legal team. Now, this is expected to be the courtroom arrangement that I've explained so far, and I hope it is clear and precise. You can picture it in with your imagination. Now, once that one is settled, the court will move into the formal opening of proceedings. The case will be called by the court registrar or clerk. The suit number will be announced alongside the names of the parties involved, and that is Nnamdi Kanu versus the federal government of Nigeria, depending on how the matter is officially styled before the court. And now, once that is done, the case will officially begin. And after the case is called, the lawyers and parties involved will have to identify themselves before the courts. That part is always usually straightforward. Counsel for the appellant will announce their appearance, while counsel representing the federal government will also introduce themselves. If Nnamdi Kanu intends to personally address the court in any capacity, that would also have to be acknowledged formally by the panel. For example, counsel may rise and say, "My lords, I appear for the appellant." Likewise, counsel for the federal government may say, "My lords, I appear for the respondent." Now, once appearances have entered, the court moves into substantive proceedings. The judges may ask both sides to state why they are before the court and what reliefs they are seeking. The appellant, which in this case is our very own Mazi Nnamdi Kanu, well, the appellant may raise issue concerning the judgment of the lower case, which was the High Court, and then the procedural complaints, constitutional questions, bail applications, jurisdictional argument, or applications seeking amendment to certain filings. Any application such as bail or amendments would normally have to be properly filed before the hearing date. This stage alone can consume a full day because each side must explain exactly what they are bringing before the appeal court. Now, I hope you are paying attention. Once the appellant side concludes, the respondents represented by the federal government legal team will also respond and explain their own position. They may argue that the lower court acted properly and that the proceedings were lawful and that the judgment should stand. Once both the sides now have introduced their positions, the judges will now begin asking questions Question fit come from all the three justices sitting on the panel. Any of them fit dey ask questions. And now remember that Nnamdi Kanu will not necessarily stand alone. He's expected also make him get legal counsel wey go assist am, just as the federal government side also go get supporting lawyers wey go support Adegboyega SAN. Now, the judges may ask questions such as: when was the application filed? Is this motion properly before the court? Why was this document filed late? Did the trial court actually make that finding? Now, questions like this will actually help the appeal court understand the legal foundation of each argument that are being presented. Once preliminary matters are addressed, the substantive hearing begins fully. And at this stage now, the appellant speaks first. That means the side representing Mazi Nnamdi Kanu will present their argument first before the respondent is going to reply, unlike in the High Court where it is the federal government body that their representative, their lawyers that spoke first before the accused responds. Now, I need you to notice something important here. In appeal court proceedings, lawyers do not usually attack judges personally. Instead, they focus on alleged legal errors made by the lower court itself. I hope you understand. The appellant side will have to point to alleged errors from the federal high court proceedings, whether they involve interpretation of law, constitutional complaints, procedural fairness, or trial issues. After the appellant side concludes, the respondent's legal team will respond to each argument raised. Now, the proceeding is going to move into what is called reliance on written briefs, and honestly, this is where things actually become extremely serious. Most arguments in the appeal court are already prepared beforehand in detailed written briefs. Lawyers normally rise and say, "We rely on our written brief dated." Then they will say the date before highlighting the most important high points. Now, appeal courts do not usually rehear an entire trial from the beginning. Instead, they focus heavily on legal arguments. I hope you are following me. They focus mainly on legal arguments. Now, these legal arguments have to already be contained in the written submissions that have been made by the appellant and his team. Now, this is why many observers believe that appellate lawyers are very important in this stage. Appeal proceedings require deep familiarity with appellate practice, legal citations, constitutional interpretations, and courtroom procedure. And remember, each judge on the panel will have copies of the written briefs before them. The judges may interrupt at any point in time to ask questions such as: where exactly is that contained in this record? Show me. What page are you referring to? Tell us. Did the lower court actually state that? Questions like that. And at that point, answers are expected immediately. The judges want exact references, exact pages, and exact legal authorities and exact procedural grounds as it happened. Now, there is usually no room for uncertainty in this case because the appeal court relies heavily on records, documents, and legal precision. Once the appellant side finishes relying on its written brief, the federal government legal team will respond fully. Now, they may actually challenge the appellant's arguments. They may choose to defend the lower court judgment or question procedural claims and argue why the appeal should fail. The judges may continue asking more questions throughout the process. Sometimes judges appear skeptical, sometimes they appear supportive, sometimes they even remain completely neutral. Experienced lawyers often study the judge's tone, body language, and style of questioning to understand how the panel may be viewing the arguments being presented. Now, after the arguments are completed, the appellant may briefly reply on points of law. This stage is usually limited strictly to addressing fresh legal issues raised by the respondents. It is not meant for repeating earlier arguments. Now, proceedings move into another critical stage: adoption of briefs. At this point now, lawyers formally tell the court, "We adopt our written brief." That step officially places the written argument before the appeal court for panel of for before the appeal court panel for consideration. Now, in this stage that we are now, it is legally very important because adoption of briefs is recognized is a recognized procedural requirement in the appellate proceedings, and once the adoption is completed, hearings effectively come to an end. And this is where tension usually rises, because from that moment both of the sides begin waiting to see whether the matter may eventually proceed to the Supreme Court depending on the outcome. If the appeal court delivers a favorable judgment to Nnamdi Kanu, the federal government may still choose to appeal further to the Supreme Court. Likewise, if judgment goes against Mazi Nnamdi Kanu, his legal team may also proceed to the Supreme Court, which becomes the final stage of the judicial process. Now, another important point that you must know, this is another important thing you need to know. Appeal court judgments are usually not delivered immediately after hearing conclude, unlike the Federal High Court. The panel normally reserves judgment to a later date. The presiding justice may announce that judgment has been reserved and that parties will be informed of the date it will be delivered. That judgment date may come weeks later, a month later, and even longer, depending on the circumstances of the case. Then finally comes judgment day. On that day, the judges will summarize the issues raised by both sides, review the arguments presented, and deliver their decision. Since there are three judges on the panel, the majority decision becomes the judgment of the courts. For example, if two judges agree with the appellates, while one disagrees, the majority position becomes the official judgment of the appeal court. That is how appellate panels function. So this is generally how proceedings at appeal courts are expected to look and unfold based on available legal procedures and current public discussions that are surrounding the matter. I hope you are with me. Now, tell us what you think. Do you believe Mazi Nnamdi Kanu should rely fully on experienced appellate lawyers at this stage, or do you believe he can effectively address aspects of the proceedings all by his lonesome self? I would like to hear your thoughts in the comment section for real. I said, let me break everything down we currently know regarding the proceedings, how it may go and how it may look as of today. Thanks for watching right up until this moment. It's been amazing having you here. I will definitely see you again in our next update as the case develops. Stay tuned, stay subscribed, and of course, do not forget to turn on your post notification bell so you wouldn't forget, so you would always get notified whenever we drop new updates. Thank you for sticking with us once again. For now, this will be Baz News signing out.
Thank you for watching, and please like and subscribe.